Hello, everybody. Welcome to our September 101 workshop. This month we will be talking about Workers' Rights 101. This workshop series is part of our 101 series that we do with the Green Socialist Organizing Project. Each month we look at a different topic that is important to the Green Socialist movement and give kind of a basic workshop on it. You can learn about our upcoming workshops and see recordings and podcasts and slideshows from past workshops at greensocialistnet.101s. So that's where you can go to find out more information. Like I said, this month we're going to be doing Workers' Rights 101. Then coming up through the end of the year, if you followed this series in 2022, you saw that when we started, we did Green Party 101, Eco-Socialism 101, Organizing 101, and then we repeated throughout 2022. We did each one of them quarterly. Coming into 2023, we've done each of the Green Party and the Eco-Socialism and the Organizing workshops, but we've also been interspersing other topics, like I said, that are important to the Green Socialist movement. So for the end of the month in October, November, and December, we're going to go back to that old style. In October, we're going to repeat Green Party 101. In November, we're going to do Eco-Socialism 101. And in December, we're going to do Organizing 101. But for tonight, we're going to talk about workers' rights and, really focus on a baseline. So a big part of the kind of inspiration behind doing this 101 is that if you watch Howie's podcast, Green Socialist Notes, on Saturday, you've seen that a few times we've had Bill Berry, who's a veteran labor organizer, and Natalie Menares, who's an organizer with the Amazon Labor Union in Staten Island, on to talk about their struggles, in Staten Island with unionizing into Amazon. They've won the vote, but they haven't gotten a contract. They're still fighting for that first contract, still dealing with really, really atrocious, working conditions at that Amazon warehouse, as well as Amazon warehouses around the country. So that kind of got, at the beginning of September, we had Bill and Natalie on. So that kind of got us into a workers' rights orientation for the month. I'll also say we have a member of our education working group that's been working on a Green Socialist workplace organizing series, where we'll go kind of walk through, how to form a bottom-up radical union in your workplace. That was being worked on, and that led me to, think about workers' rights as one of our 101s. Another major influence for this workshop is that I am active on the anti-work subreddit. That subreddit started as a anti-work anarchist space, but it has exploded to 2 million members, and it's largely now, for better or worse, a place where people complain about their working conditions and tell stories about horrible bosses and things like that. But one thing in my time being active on anti-work that's really come to light to me is that most workers aren't aware of their basic rights, right? We're not even talking about starting a union. We're talking about, wage theft and, things like, working, what is billable hours and how companies classify people as incorrectly classify people as independent contractors instead of employees, things like that. So that's what this workshop is about, right? This workshop isn't going to be about how to unionize your workplace, right? That's above 101 level. That's when we're getting into more advanced organizing. Tonight's workshop is really going to be about those absolute basics. So as I go through the presentation, I'm watching the comments. If you have any questions, comments, I'll try to take them as we go, or come back to them at the end as after we're finished with the presentation. I guess to start off, my name is Chris Blankenhorn. I'm the Illinois Green Party's secretary, a former GPUS co-chair, and I served as the social media and tech director on the Hawkins Walker campaign in 2020. I'm also one of the lead organizers in the Green Socialist Organizing Project's 101 series, Education Working Group, which puts on this one-on-one series. You can learn more and get involved with the Green Socialist Organizing Project at greensocialist.net. But as always, we're covering a very, very deep topic. So I'm going to get started. Pull that out. So Workers' Rights 101. To start off, well, like I said, this workshop is about the basics of the basics, right? This workshop isn't about, how to effectively, organize a union in your workplace. We're working on a much broader series, right? You can't really, we could go over basics, but we really can't do justice to workplace organizing in an hour span. So that's going to be a whole other thing, probably a multi-series workshop that we're working on. But tonight's just about the basics of the basics, right? And so to start off, the first thing that workers need to understand is that as workers, you have rights in your workplace, and they're established by federal, state, and local level laws. These laws vary very, very broadly by location, right? Though there are federal locations that apply broadly. That said, while we, don't have the level of workers' rights that some other nations do, there is a baseline that applies to nearly all workers. So that's going to be one problem that that we have to address in this workshop is that what workers' rights looks different in Arizona versus New York versus Illinois versus Texas, right? Versus Washington versus Montana. And so there's going to be a lot of specific details that are really location dependent and really situation dependent that we're not going to be, we can answer questions on them and try to suss it out. But overall, this is going to kind of be about that baseline. So that baseline includes, but is not limited to, freedom of association and the effective recognition of the right to collective bargaining, right? We're not going to get into organizing unions today, but you can, right? It is a protected right. Workers have the right to collectively organize in the United States, and that is with or without a union, which we'll get into a little bit later. The right to these baseline rights include the elimination of all forms of forced or compulsory labor. There's a little asterisk out there with the 13th Amendment that allows for slavery and forced labor, compulsory labor to continue within prison systems. But in general, in the general, economy, you have the right to not be forced to work. The effective abolition of child labor, again, right? We're seeing we've recently seen states passing new laws that allow younger and younger kids to work. We do not have, top of the line protections in this sphere, but there are protections. The elimination of discrimination in respect to employment and occupation, and then a safe and healthy work environment. And so while we do have these baselines, right, we can put an asterisk for every single one. There are things that we can talk about with every single one where we either aren't actually receiving full protections or we aren't seeing enforcement, right? It may be the law that you can't be discriminated against, or it may be the law that you have a safe and healthy working environment, but that doesn't actually mean that you have that on the ground. And to go back to this, point I made at the very, at the beginning of that last slide, what your rights are as a worker varies widely depending on where you live, right? We've got federal level laws that provide a baseline protection, and then different states have different laws, kind of depending on their different levels of protection depending on their laws, and then there's municipalities that also have their own protection. So here's a couple of maps, right, that kind of show the diversity that we have across the states. And then this diversity is of laws is one of the things that makes it really, really hard to, engage in national level organizing, right? Much like running for office as a third party means we have to deal with 51 different election and ballot access rules, and that makes it hard for us to organize nationally. The same is true for labor laws, right? Because each of the states has their own specific laws, it makes it a whole lot harder, to have mass action in terms of labor. But some maps up there. The first one you see is state minimum wages as of July 1st of 2023. The more orange-red a state, the higher their wage. All of those light blue states have the federal minimum wage as their minimum wage. Next up is the change in union membership, right? And if you look at the change in union membership, you've got deep red in Wisconsin, where we saw big attacks under the Scott Walker administration on collective bargaining of union members. But even traditionally, states that are traditionally thought of as very progressive states, Illinois, Minnesota, New York, they're red, which means that they're seeing a decline in union membership. The next slide with the blue map is is a map of pregnant worker fairness laws. So where pregnant workers have varying levels of rights, and you'll see, right there, most of the country, we don't have, strong rights supporting, reproductive freedom. The first one on the bottom, ranking public sectors, again, right? Illinois is traditionally thought of as a deep blue state, but we are deep blue with a D- grade there. New York, again, another, traditionally thought of, really strong blue state. It has a D. California has an F. So even our more liberal states have really bad ratings when it comes to their public sector. Next map is looking at farm worker overtime, which almost no states have protections against. And then kind of tying in with the pregnant workers fairness laws, the map on the bottom shows the countries that have paid parental leave. And of course, the United States is one of the only countries in the entire world that does not offer that. So these maps aren't so much to dive into, but just kind of an illustration of the fact that where you live is one of the biggest factors in determining your rights as a worker. And it's one of the big problems that we have in, pushing back against capital, is that we have to fight 51 different battles, right? The 50 states plus DC, plus, fighting for things in Puerto Rico and Guam and the other colonies that the United States maintains. So we have to fight these battles in individual states. We can't have a mass unified front and a mass unified organizing project, because the laws and the conditions are so different depending on where you live. To start off with a couple early ones, or some kind of big name things that you need to do, we need to think about. First off, at-will employment. Every single state but Montana has at-will employment, though there are different exemptions and applications between the different states. What at-will employment means is that either the employer or the employee may end the employment at any time, with or without reason or cause. So this means you can be fired and they don't have to give you a reason. I actually read a post on Reddit this week about someone who worked at a car dealership. They worked at a Hyundai dealership. They went to the Toyota dealership next door and bought their car. It was owned by the same, auto dealer conglomerate company, but they were fired as soon as they came to work with a Toyota at their Hyundai, right? They were literally fired because of the type of car they drove, and it's perfectly legal in an at-will state. The people often joke you can be, fired because of the kind of car you drive, the kind of, soda that you like, those type of things, or you can be fired for no reason at all. There are wide ranges of ways in which at-will employment can be modified by a contract, but the baseline is every state but Montana is at-will. And while this doesn't necessarily exclude businesses from accountability in terms of termination, being a violation, of other aspects of labor law and protections, so they can't fire you for being gay. They can't fire you for being pregnant. Those are protected. We'll get into protected classes later. But what it does open up to is they fire you when you get pregnant and just tell you no, there's no reason, right? They don't say that they fired you for being pregnant. They come up with another reason or no reason at all. And so that's kind of the negative of at-will employment. It generally also allows them to, have But on the flip side is it's what allows us, as a worker, to quit and give no notice, right? People often talk about 2-week notice like it's some legal thing. There is no, unless you have a contract that states otherwise, and even then the contract can likely be called into question in most at-will states, unless, in general, you have no obligation to give notice, right? You can quit and walk out today. It may burn the bridge. They may not be a reference, but you cannot be forced to give notice in most cases. And I feel like almost everything said in this workshop kind of has that "in most cases" asterisk, right? Because we're dealing with so many different laws. It's hard to talk broadly about them as a whole. Another big term that we often hear in labor organizing and workers' rights is right to work. And this is often confused with at-will employment because it's got this, misleading name. To be frank, the Republicans have always, in the conservative, flank of our society, has always been better at, naming things, right? The estate tax is the death tax, death panels when they were passing the ACA, right? The Republicans have always been good at this type of stuff, and right to work is another example. When you hear the word right to work, it makes you think of at-will employment, right? That seems like how that would play out. But what right to work actually means is that unions cannot collect dues from non-union employees to cover the cost of the union negotiating collective bargaining agreements, which the non-union employees benefit from. Even before right to work laws were passed, precedent had been established that no one can be forced to join a union in most places and in most industries. But these go even further because it used to be, outside of right to work laws, if you are a non-union member and a pay raise gets negotiated that you still had to pay kind of like administrative fees to fund the negotiating team that actually got you that. Under right to work, you can not be a member of the union. You don't have to pay any administration fees, and you can, just take the raise and continue on. So you can get all of the benefits of union ownership without paying dues, without paying fees. It's the epitome of the free rider problem. Some stats on right to work. Right to work states have 36% more discrimination complaints. Again, we're weakening unions with these right to work states, so that's not surprising. There is on average a 3.1% pay drop across the state wages when a right to work law is passed. So when these laws pass, almost immediately wages drop. And then 24% of jobs in right to work states are considered low wage or low income occupations, and that's compared to 14% of the jobs in other states. So when we go at unions, when we hurt unions' ability to collectively organize, when we kind of untether workers from the union, we see these negative impacts. Next up is the big one, right? Wage theft. According to the Economic Policy Institute, wage theft costs U.S. workers $50 billion a year. $50 billion every year is stolen from workers. This can be through minimum wage violations, overtime violations, rest break violations, off the clock violations, and we'll get into these in a minute, right? This number is more than every other type of theft combined, and most years it's more than every other type by a factor of 2 to 4 times, right? And you can see that in the chart. When you combine larceny and burglary and auto theft and robbery, it still doesn't even come close to being it's probably about 50% of just minimum wage violations, right? So wage theft is a huge, probably one of the biggest workers' rights issues, that we face in this country. And on the other side of it, 50 million is stolen, or 50 billion is stolen. But only a small percentage of the money is actually recovered through enforcement action, whether that be, through state government, state, federal, or local agencies, or through, suing with the private attorney. From 2017 to 2020, only 3.24 billion was recovered, right? So every year, 50 billion is stolen, and on average, every year, less than $1 billion is recovered. So we're talking about like a 2% or lower recovery rate when it comes to wage theft. A vast majority of workers experiencing wage theft never file a claim. A lot of that is that they don't know how, they aren't aware of their rights. I have been in many places where experienced, HR people say things that are outright illegal federally. That they encourage workers, especially things like off the clock violations, are really, really normal. Minimum wage violations, tip violations, these are really, really common. And a big part of the reason why is there's not much of a disincentive for these companies to not engage in wage theft, right? Wage theft is often treated more like a civil issue than a criminal one. When your boss commits wage theft, they receive fines. It's kind of taken care of through an administrative process, right? If you as the worker took $100 out of the cash register, you're going to be arrested. When $50 billion are stolen from workers every year, no one's arrested, right? Very few of them even have to pay back what they've stolen, and even fewer pay things like fines. And even when they do get a fine, it's a slap on the wrist, right? It's a very, very small fine in comparison to a number like $50 billion that's stolen. Wage theft is, broadly is a failure to pay workers the full wages to which they are legally entitled. Wage theft can take many forms, including but not limited to minimum wage violations, which is paying workers less than a minimum wage. This can happen in overt ways where you just pay someone less than a minimum wage, but oftentimes it happens because someone's on a salary, like a manager at a fast food restaurant, and they end up working 60 hours a week, and it drops their hourly wage to below minimum wage, right? You cannot, and this is something that's true kind of across a lot of these, issues that we'll talk about tonight. You can't sign away these rights, right? You can't sign a contract that says, you'll be away, you'll work for nothing, that you'll work for below minimum wage. And the minimum wage violations are, the largest percentage of all of this, of wage theft. And it happens, and we're talking about, the workers that are the most oppressed, right? The workers that are the most exploited. And they often don't know their rights. And if they do know their rights, they don't know how to, stand up for them, how to advocate for themselves, how to seek redress from different places. And that means and they're also often in a situation where they need the job, right? They would very much like to file a complaint, and even though retaliation is legal, much like wage theft, it's not very well enforced. So oftentimes, even if they know their rights and they know what they need to do, they don't, because they can't afford to lose the job. They can't afford to be fired. They need to, put food on the table, a house over their heads, and take care of their families. Overtime violations are failing to pay non-exempt employees time and a half hours for hours worked in excess of 40 hours a week. There is some, some states do it by week, some states do it by day. There's some little variation in how overtime is calculated. But across the board, there are a lot of employees that are called exempt, which means that they're a salaried employee that doesn't get overtime, who actually should be categorized, as non-exempt and thus getting overtime. Off the clock violations, with asking employees to work off the clock or before their shift. It's super common in retail and even in office buildings that people are expected to clock out and continue working, right? We close at 9, but you can't leave till you're done cleaning. That's illegal. If you're doing work that's required by the business, that's mandatory, you must be paid. And in 2022, federal courts even extended this officially to even the booting on of your computer, which is one that I see a lot. I see a lot of times people will be told, you're not pressing power at 8 when you clock in. You need to be logged in and ready to start working at 8, and that's illegal. You have to be paid for the time you press power on your computer while it boots up, right? So I work for a state agency, and I have a crappy standard hard drive laptop, and from when I push power to be between when I can do things is usually 10 to 15 minutes, but I must be paid for that time. If the business wants me to be able to start work at 8, the business either needs to pay me to come in at quarter till, or they need to get a computer with a solid state hard drive that can boot up in less than a minute, and then we can get going, right? But if you're doing work, if it's mandated by your bosses, and Amazon just paid out a huge amount of money to workers for making them be off the clock and wait in line to get their bags checked to make sure that they weren't stealing anything from the warehouses. And they just paid out millions and millions of dollars in a settlement with workers over that, right? So if your boss says you have to do it, you're paid, period, end of story, no negotiations on that. Meal break violations, again, in my time in the service industry and in retail, super common, right? That you just don't have, you're short-staffed and you don't get to take a lunch. You don't get to take your allotted breaks. And that's another case of wage theft, right? If your work day is is paid with a half an hour, and this happens all the time, they'll say, don't take your lunch, but we're still taking the half hour from you. Again, wage theft, pay stub and illegal deductions, right? Taking more money than they should, messing with the kind of withholdings and that kind of stuff. Tipped minimum wage violations is another huge one in the food industry. You cannot confiscate tips from your worker. If a worker works a slow shift and does not hit minimum wage, they must be paid up to that minimum wage, right? Because tipped workers are often receiving $2 an hour. If nobody comes in and nobody tips them, then the business has to pay them an hourly wage that gets them up to that rate. One area where this, tipped wage violations come in is a lot of management cannot take your tips. Management shouldn't be getting paid out in tips. And that's something that happens in a lot of food service industries where, I've worked places where basically anything that someone put in our tip jar, the owner expected us to put in the till. And that is illegal. That's something that they're not allowed to do. It's stealing the wages and the earned tips of the workers. Another big one is employee misclassification violations, and we'll get into this in a little more in a minute. But it's about misclassifying employees as independent contractors, which allows employers to generally pay lower wages. So, since we're talking about wage, another important things to understand, and there's some exceptions to this, but for most workers, you are allowed to talk about your pay. This right applies to being able to talk to your coworkers about your pay, as well as anyone else. You can talk to the media about your pay. You can talk to union organizers about your pay. You can talk to government agencies like the Department of Labor about your pay, and you can talk to the general public about your pay. It is not only is it illegal for you to be punished for talking about your wage, it's illegal for employers to have a policy against discussing your wage, right? And so one thing that, when we get at the end of this workshop, we'll get into kind of how you can advocate for yourself. But one big thing that makes advocating yourself a whole lot easier is if you can get your employer to put it in writing. Right. A lot of time managers they want to call you. And one of the reasons they want to call you is, one, it's easier to apply social pressure that way. But two, if they put it in text, if they put it in email, if they put it in Teams or whatever, internal communication software your employer uses, that's now something they've officially said. You can screenshot it, you can copy it, right? And so you really want to try to get these in writing. If your employer has a policy in their employment manual saying you can't talk about wages, that's generally illegal. There's a few exceptions, but you should contact the Department of Labor about that. And furthermore, the employer cannot retaliate against you for discussing your wage. They can't change your job duties. They can't make your work life worse. They can't take official disciplinary action up to and including termination. And that's something that's true for most of these issues, right? You can't be retaliated against for standing up for your rights. And that's not to say it doesn't happen. It absolutely happens, and employers absolutely get away with it. But in general, it's against the law, right? They're just skirting it. They're getting one passed on people when that happens. So a big area where companies play games and do things to their benefit, and one of the common forms of wage theft is the misclassification of employees as independent contractors instead of normal employees. When classified as an independent contractor, the employer doesn't pay taxes or provide the same benefits as it does to the employees, but in turn, the employee or the contractor operates with a high level of autonomy and control over their work, right? So you often get independent contractors will often get a little bit higher of a wage, but that's because they're not withholding taxes. So at the end of the year, you're going to owe taxes on everything you've earned because nothing's been withheld. Similarly, independent contractors often don't receive, healthcare benefits or other benefits that a full-time employee does. The trade-off, because it's supposed to be a balancing act with these two classifications, is that employee is supposed to have more control. And so 3 key areas where that can play out is behavioral. Does the company have control or have the right to tell the worker what they do and when they do it and how they do their job? If your employer is setting your schedule, that is a mark in the box that you're not an independent contractor. If your employer is telling you what to do and when, you're probably not an independent contractor, even if you're classified as such. Financial, are the business aspects of the worker's job controlled by the payer? This can include things like how the worker's paid, how their expenses are reimbursed, who supplies the tools, right? If you are not setting your own hours, if you have to provide your own computer, or things like that, or if they provide all your tools, things like that, these are things that are making you more and more likely to be an employee and not a contractor. And then the type of relationships, how are the contracts written, or the benefits passed on? Will the relationship continue, and is the work performed a key aspect of the business, right? So if you're doing essential work to a business as an independent contractor, another check mark that you're not actually an independent contractor. If you think that you are misclassified, you can fill out this form SS8 with the IRS. It is the determination of worker status for purposes of federal employment taxes and income tax withholding. You fill out this form, you answer questions, and the IRS will give you a definitive ruling on whether you're an independent contractor or an employee. So if you find yourself in this position, go fill out this SS8 form if you think you're being misclassified, and they will give a binding decision. That doesn't mean that your employer then couldn't say, well, we don't want to hire you as an employee. It's an at-will state, you're fired. But it sets you up to be properly classified. Another big one is workplace equity. You have the right to join with your coworkers and demand a diverse, equitable, inclusive, and accessible workplace. Workplace equity, with the right to not to be discriminated against in the workplace, is protected by various agencies at the state, federal, and local level. These include things like the Equal Employment Opportunity Commission, the Department of Labor, and the National Labor Relations Board, as well as many others. In addition to the right to having a workplace free of discrimination, you have a right to organize and protest against discrimination in your workplace, and your employer cannot prohibit you from engaging in that activity or advocating for these rights. You also can't be retaliated against for taking such action. If there's open racism happening in your workplace, you and your coworkers have the right to collectively demand change, and you can't be punished for that. You also have the right to, raise it as an individual, but you're always better in collective action, right? The more we can unify together as workers, the stronger position that we have in these fights. So here's the asterisk on that. Here's the catch with the right to having an equitable workplace, to the right to not be discriminated against. They only apply to what are called protected classes in employment. Applicants, employees, and former employees are protected from employment and discrimination based on race, color, religion, sex, which includes pregnancy, sexual orientation, and gender identity, national origin, age, which only applies to people 40 and older, disability, and genetic information, which can include your family history. Again, you're protected against retaliation for filing a charge or a complaint of discrimination, participating in a discrimination investigation or lawsuit, or opposing discrimination in your workplace. For example, threatening to have an investigation come regarding it. And so only these protected classes have legal protections, and that's a major hole in our workers' rights laws and our worker protections, right? When people use the term hostile work environment, these are the only people that can claim that. Unfortunately, it is perfectly legal for your employer to have a toxic work environment. It is perfectly legal for your employer to be an asshole, right? It's as long as they aren't discriminating based on one of these protected classes or breaking another labor law, they can be total shitheads, and there's nothing illegal about that. Like I said, it's a huge hole in our employment law, but these protected classes do enjoy a level of protection from discrimination. And so down at the bottom, there's a link that gives you more information from the Equal Employment Opportunity Commission. Tied to that, right, reproductive protections and the Family Medical Leave Act. The United States is one of only 7 member nations that does not pay some level of paid time off for new parents, right? Only one of 7. And even when you can look at the map, even when you look at the map state by state, right? Because while the location-centric, legal system that we have in place for these laws is a problem to organizing, it also, on the other side, does in some ways allow states to enact, more strict laws than what we have as the federal baseline. But when we look at this map, what we see is that states aren't doing that, right? Very, very few states have enacted their own paid parental leave policies. The United States federally has no policy. The dark blue in this map are states that have it already enacted. The light blue are ones that at the time of the making of this map in 2022 had passed laws that were not into effect yet, right? And while we do see some of the, the states that are considered more progressive, California, Washington, New York, having these things, there are also major progressive states like Illinois and Minnesota that do not have any protections. In Illinois, we just in the last year or so passed a law, which is where I'm from. We just in the last year or so passed a law that said all workers must get 5 days of paid sick leave. Right, that's as far as we've gotten in completely Democratic controlled Illinois. Right, we have a Democratic governor who's considered one of the most progressive in the country, and we have super majorities of Democrats in both our House and our Senate. Yet we have no paid family leave, and it does not seem like it's coming. So we don't have paid family leave. What we do have federally is the Family Medical Leave Act. The FMLA. It provides certain employees with up to 12 weeks of unpaid job protected leave per year. It applies to all public agencies, all public and private elementary and secondary schools, companies with over 50 employees. These employers must provide an eligible employee with 12 weeks of unpaid leave each year. There's a few reasons, like the birth of a child, the placement of a child for adoption or in taking on a foster child, the immediate medical care of a family member, like a spouse, a child, or a parent, and they have to be able to take the leave when take this medical leave when the employee is unable to work because of their own health condition, right? And so these protection, the FMLA, means that they have to maintain your health benefits. They don't have to pay you, but you have to keep your health insurance going, and they have to protect your job upon your return. One thing that I just learned in the last couple of days is that if, for example, there's a spouse, there are two spouses, they work at the same business and they have a child, they do not both get 12 weeks. If both partners work at the same employer, they have to split the 12 weeks. So that's one of those asterisks. Antonino says, one thing that really irritates me is that ageism is okay against younger people because they are not a protected class. Absolutely, right? We go back to that previous slide. Age is only protected under 40. So young people can be discriminated against for being young people. It's only when you get over 40 that you get that kind of protection. The ageism protection only applies to the high end of the spectrum, not the low. Immigrant worker rights. You're protected under the National Labor Relations Act, regardless of your immigration status. Immigrant workers are afforded the same rights as naturalized workers and protected from discrimination, just like everyone else, based on their national origin. One example of this is that it extends to banning English-only rules in the workplace. That doesn't mean they can't say you have to speak English when you're speaking to a customer or something like that, but there cannot be a total ban, right? They cannot ban employees from speaking behind the scenes in their native languages. And this right to protection regardless of immigration status is guaranteed by the Civil Rights Act of 1964, the Immigration and Nationality Act, and other laws, executive actions, and regulatory decisions. So while this is an area I don't think most people know, right, that it doesn't matter. Your immigration status does not matter. The labor protections apply. And I think this is one of those areas that we see, possibly more than others, egregious violation, right? It's pretty common knowledge that immigrants in this country are taken advantage of, are exploited, and that their immigration status is leveraged, to support that oppression and that exploitation. So it's really important that we, that people know this, that you can't have your immigration status held against you or used as kind of a blackmail against you to keep you in line. So, like I said at the beginning of this workshop, we're not going to get into forming a union, right? That's not a 1 hour conversation. I think we'll go a little long tonight, but that's not a 1 hour conversation. That's not a one workshop conversation. That is a big, big, big lift. And we're working on content on forming a union, but that's not what this is about. This is about, like I said, the basics of the basic. That said, it's really important to know that employees who are not represented by a union still have rights under the National Labor under the NLRA. Sorry, specifically the National Labor Relations Board, which is the body that's was created and empowered by the National Labor Relations Act, the NLRA, protects the right of employees to engage in concerted activities, which is when two or more employees takes action for their mutual aid or protection regarding terms and conditions of employment. A single employee may also engage in concerted activity if he or she is acting on the authority of other employees. So if you and your coworkers band together, you have the right to collectively advocate for yourself, or you have the right to have one member of your kind of work group to advocate on your behalf as a proxy. So you can act on the authority of other employees, bringing group complaints to the employer's attention, trying to induce group action, and seeking to prepare for group action. A few examples of protected concerted activities are addressing employers about improving pay, discussing work-related issues beyond pay, such as safety concerns with each other, and speaking to an employer on the behalf of other people about improving workplace conditions. There's a link there, and once this workshop is done tonight, I'll get a bunch of links and stuff put into the YouTube description. It's the same thing when it comes out on Thursday as a podcast on podcast networks. We'll get links, and we'll have all of that available on the website as well. But you can go here, and there's a link there that will take you to see more kind of case examples of what concerted activity is in the opinion of the NLRB. Like I said at the beginning, retaliation occurs when an employer treats applicants, employees, former employees, or people closely associated with these individuals less favorably for reporting discrimination, participating in an investigation or a lawsuit, opposing discrimination or illegal activity in their workplace, asserting their worker rights, filing a complaint against their worker rights, or cooperating with an investigation. Now, again, I've said numerous times, that doesn't mean retaliation doesn't happen. A big part of the calculus, in my opinion, for corporations and for employers is that you don't have time for these fights, right? So if you raise an issue and they fire you for raising a workplace safety issue, for example, you have the right to seek redress, whether that be through the Department of Labor or a similar agency, or through a private lawyer in filing a lawsuit. But the reality is, for most workers in the United States are living paycheck to paycheck. They don't have a savings. They don't have the time. When they lose their job, they've got to find another one because they've got to put food on the table and keep a roof over their head. So the employers really bank on you not knowing your rights, on you not knowing how to seek redress, and on you not having the time and the energy and the resources to actually pursue justice when things, when retaliation or when illegal activity is taking place. So what do we do, right? I just spewed a lot of, basics of worker rights, but what do we do when these things are violated? Like I talked about, most of this stuff happens all the time across industries, across sectors. Obviously, low paying jobs are worse. Obviously, service and retail industry are really, really heavily involved in a lot of these things. But when we see it happening, right now that we know our rights, what can we do? How can we advocate for ourselves? And the first step for advocating yourself and making positive change in your workplace is knowing and standing up for your rights, right? So the first step, like with almost everything, is educating yourself and making a stand. There are government agencies, there are federal, state, and sometimes local workers' rights agencies that can investigate violations and enforce relevant labor laws. The exact nature of these agencies and which one you should call is really, really situational and location dependent, right? Government agencies can not only help you, but they can potentially help your coworkers. The one side effect of this is that it is often a very slow process, right? And so that's one thing that I always tell people when I'm talking to people about workers' rights and advocating for themselves and, filing a complaint with the Department of Labor, for example, is I always tell them it's a slow process. So they're going to have to understand that it's the government. So it's not going to move quickly, but it's really, even if you're quitting, right? Even if you're done and they've stolen your wages and you're not going to fight with them anymore and you're done, still file the complaint, right? Because while it may take months, it could get you those back wages. And maybe even more importantly, it can get your coworkers that are still stuck there. It can get past coworkers, right? Once one person files that wage complaint, they start digging. And all of a sudden, people who never even filed a complaint are getting redress. They're getting, justice. They're getting back pay and things like that. So I always encourage people, even if you're throwing in the towel, even if you're not going to go for private legal action, even if you're not going to stay in your workplace and fight, on your way out the door, file the complaint, right? Or maybe right before you walk out the door, file it while you're still an employee, and then, make your exit. But file it, right? Raise the issue, start the investigation, because in the long run, it could help you, and it could help your coworkers, and it could help people that you never even knew who had been screwed over by that employer years before. It just opens a door that companies really don't want, right? They don't want to be investigated. They don't want auditors looking through their books and seeing what they're doing, especially if they know they're engaged in illegal activity, which most of them are aware that what they're doing is illegal. You can also take private legal action. Labor lawyers will often provide a free consultation and work on a contingency where they get the percentage of the winnings, right? A lot of times, because of the heavy, situational and location dependency of whether or not something's illegal or has crossed the threshold into a labor law violation, you really need advice, right? And labor law is one of those legal areas where they will often give you that advice for free, and they will often work where they'll say, I'll take X percentage if you win. So it's a little more accessible area of law oftentimes, because people who get into the worker side of labor law tend to want to help people, right? They don't want to say, well, I can't help you because you can't drop a $5,000 retainer for me, knowing that you're a minimum wage worker who was screwed over by McDonald's, right? They know you don't have that money, so they'll often take you on a contingency. Collective action, right? If you're staying, you do not need to be in a union, like I said earlier, to collectively advocate for yourself and organize for change in your workplace. This can go from collectively advocating and negotiating, around issues, like was mentioned on one of the previous slides, right? That you can actually go and, raise issues collectively or as individuals, to your employer, and try to, talk it out and try to come to a common agreement, to try to come to a settlement. You can do that, but you can also engage in slowdowns, right? You can work less effectively. You can take actions, and again, it's all really specific to your job and your conditions, but there's plenty of actions that you can take that can put pressure on your employer, to give concessions and to work with the employees to improve conditions, because if they don't, they're going to continue losing money. Now, you can get fired for these things, right? When you don't have the union protection, you can be fired for these things. But like I said, 49 out of 50 states are at will. So you can be fired for any reason without reason. So remember, and this collective action can go as far as strikes, right? You can strike without a union. Again, it's a risk. They can fire you off day one of the strike and try to hire new people. But there are often times and situations where that's not possible, right? It may be a situation where your employer can't afford to not run for a day, a week, a month, months as they restaff. So a wildcat strike, it wouldn't technically be wildcat, because there's no wildcat strikes are when strikes happen against the union leadership's vote, but it would be like an unorganized strike can happen and they can be effective. Like any kind of a collective action, though, it really demands that you and your coworkers are unified, and that you're going to, really fight, stand together and hold the ground. Otherwise, you're only as strong as your weakest link, and it can all easily fall apart. And then again, the final step in all of this, in advocating yourself, and the one that we're not going to dive deep into tonight, is you can always organize a union, right? You have a right to organize a union. Like most labor rights and organizing, how this happens is really heavily situational and really location dependent. What I always tell people when talking about forming unions is step one is a soft count, right? Who's with you? Who's against you? Who do you not want to even ask, because they'll rat you out, right? But you can start getting your soft counts through conversations. And I used to work at a school that we only had 9 employees. And the main reason that I never tried to start a union at the school was over half of our employees most of the time were either family with the owner or related or in a relationship with the owner, a member of the owner's family, right? So when I've got 9 employees, but 5 of them are the owner's kids, and the owner's kids' spouses, I don't think I'm going to win that vote. So I can't really start the fight. In a different situation, I may be able to look at my 9-person, workplace and say, I've got seven of us in the bag. Let's organize. Let's hold this union vote. Let's let the NLRB count it, and let's become an organized workplace. A little deeper into the what to do, and especially the government agencies, the Department of Labor and similar state and local level agencies investigate violations and enforce labor law on a wide range of workplace issues. The U.S. Department of Labor is made up of a wide range of federal agencies, from ones that do like data and research, like the National Labor Statistics, to industry-specific agencies, like an agency that oversees mine safety, to health and safety, like OSHA, to veterans employment, right? So the Department of Labor is a department that has, a couple dozen kind of work and sector-specific agencies that all work around, protecting workers' rights. In addition to its enforcement functions, the Department of Labor maintains a huge number of really, really, really good resources for workers. I've got a resources page at the end that we'll talk about briefly that has some of those. The National Labor Relations Board is traditionally more oriented towards union organizing. But that said, it also protects broad workers' rights. Which of these agents, like I said, it's a lot of it's situation specific on which one of these agencies is actually enforcing the law that's being broken. Sometimes the law being broken is under the purview of the Department of Labor. Sometimes the law that's being broken is under the purview of the National Labor Relations Board or OSHA. So you need to figure out who you need to talk to. Generally, I would say that if you contact the Department of Labor and it's a workplace safety issue, they won't just say no. They'll say, no, you need to talk to OSHA. So if you do go to the wrong one, the people working at these agencies, even in conservative places where you wouldn't think that they would have a strong, Department of Labor, the people who sign up to work at the Department of Labor tend to be allies to the workers, right? So even if you're in, Florida or Arizona, when you go to the Department of Labor, you're most likely now they may be underfunded and they may be undersupported, so they may not be horribly effective at their jobs, but they are generally going to be people who want to help you, that want to help you navigate the bureaucracy, navigate the laws, and to advocate for yourself. But the National Labor Relations Board is the federal agency in charge with overseeing organized labor, which is union activity, and protecting workers' rights. It was established in 1935 by the National Labor Relations Act and is empowered to protect workers' rights to organize. Part of its role in overseeing union activity is the NLRB is who counts union votes when votes happen. So when Amazon workers in Staten Island or Starbucks workers across the country are trying to organize unions, when they have their vote of the employees of whether or not they should join, it's the NLRB that counts the vote and then oversees the election. And I think it's really important for people to understand, too, a lot of times when I've talked to people about workers' rights, they think a lot of this is new. No, right? These laws, the NLRA, the National Labor Relations Act, was passed in 1935, right? It's almost a century old that some of these baseline laws have been put in place. And things like you have to be paid for all the work that you do have been around, right? And so it was just in 2022 that courts expanded the definition of you have to be paid for for mandatory work to include booting up your computer, right? Because in 1935 there was no such thing as booting up a computer. So these laws have been around a long time, and they've been evolved over time by the agencies and by lawsuits and by court decisions. What to do? The Employment Opportunity Commission is responsible for enforcing federal laws that make it illegal to discriminate against job applicant or employee because of those protected classes, right? Race, color, religion, sex, pregnancy, gender identity, sexual orientation, national origin, age, over 40, disability, or genetic information. Andrew Hager had asked the question, could a retaliation also help those who are, or I assume, could retaliation also help mean retaliation protection, also help those who are physically and mentally disabled? The EEOC is going to be, the primary body federally who's going to, fight for those things, right? So if you are, if you have some kind of disability, whether that be physical or mental or social or whatever, if you've got some kind of disability and you feel that you're being discriminated against, the EEOC is who you're going to look to, right? And most businesses are required to have EEOC information and OSHA information, posted. And so, to kind of get to what I think Andrew's question was, could it help those of us who are physically or mentally disabled? The EEOC is who protects you there generally, although the other agencies most certainly have overlap into it. So the protection already exists. Retaliation is about when you file with the EEOC and say, I'm being discriminated against because of my disability. And then your employer fires you or demotes you. That's where retaliation comes in. And all of these agencies have protections against retaliation. So if you file an OSHA complaint, if you file an EEOC complaint, and then you face negative impacts in your work, all of these agencies have, have components to them to pretend, kind of legal standing that retaliation is illegal. So it'll also protect us from prejudice of able bodies and neurotypicals. Yes and no, right? This is where the situational dependence really comes in. Where these laws really protect you is from your employer. But, right, you are protected from discrimination based on those protected classes. And so this is kind of where I said earlier, hostile work environment isn't that your workplace sucks. It's that there's discrimination based on protected class, and there's rules on what rises to the level of discrimination. So someone, saying something shitty doesn't necessarily rise to the level of legal discrimination according to labor law. When you start adding things in, like you've asked them to stop being being prejudiced, it's been addressed. When you establish that it's a pattern, those things, kind of each one of those boxes you check opens the door further and further for potential action. And especially, I feel like we've really kind of seen a move in the last, few years or decades, where businesses are moving in the right direction gives them too much credit because they're mainly covering their asses. But I feel like in general, businesses have become better over time about protecting their employees from inter-employee prejudice and disputes, because of the fact that if my coworker is discriminating against me for one of the reasons of the protected classes, and I can establish that it's a pattern of harassment. I can establish that the workplace isn't doing anything. Now that employers really open themselves up to legal trouble, right? Now I can file a lawsuit against them. And so we're not in a good place, but I do think we've been slowly moving in that a better direction, as DEI, diversity, inclusion, equality, and DEIA, diversity, equality, inclusion, and accessibility, becomes more and more the norm, especially in larger businesses. Now we see states like Florida trying to ban that stuff, right? So it's not universal. It's very location dependent. But The protections are largely about your employer, and to get to the level of what is considered legal discrimination, it's got to be kind of repeated, and they've been told to stop, and reaching a level of harassment. OSHA, the Occupational Safety and Health Administration, was formed to assure safe and healthy working conditions for working men and women. OSHA gives the OASF, the Occupational Safety and Health Act, gives workers the right to a safe and healthful working condition. It's the duty of employers to provide workplaces that are free of known dangers that could harm employees. OSHA is empowered to serve as the regulatory and enforcement body in this regard. So if you are a cook in a fast food restaurant and there's no air conditioning in the middle of the summer and your kitchen is 120 degrees, OSHA is kind of who will help you in that realm. If you're a steel worker and you don't have protections, if you work in an Amazon plant, right, or an Amazon warehouse, OSHA's your friend here. Same for like FedEx and UPS. That's who's going to kind of deal. OSHA's who's going to deal with those safety issues. So like the Department of Labor is going to be your broad. The NLRB is going to be more about organizing. The EEOC is going to be about discrimination, and then OSHA is going to be about safety. And like I said, all of these have a level of overlap, right? They're a Venn diagram that doesn't have isolated silos. And most of these also, I'll say most of those types of agencies also exist on a state level and even a local level, right? So you can have these conversations, with the federal and as well as state agencies to help you, get moving on getting justice. Kind of next step after the, talking to state agencies. While there are governmental agencies that investigate and enforce labor laws, there are times when engaging a private lawyer for assistance with your situation may be necessary or beneficial. That could be because of speed, right? You need action faster than generally comes from government agencies. That could be because of the level of violation that you're dealing with, right? It may rise to the level of a civil suit, a civil lawsuit against your employer, as opposed to just an enforcement action from the agency, right? If something really egregious has happened, you can file a lawsuit and seek damages. The agencies tend to not deal so much in damages, but like back pay and making sure that what was done wrong was corrected, and then maybe some fines and things like that on the terms of the employer. But they're not there to get you a big payout. They're there to get you what was owed, and then the rest, the fines and stuff are usually just a slap on the wrist that don't matter to most businesses. So there are definitely times when lawyering up makes sense. Most state bar associations maintain a list of attorneys in various areas of law that can help you find a local labor attorney. So if you don't know of one in your community, you can usually go to your state bar association, and they'll have a Facebook like a list, not Facebook like the social media platform, right? They'll have a directory. There's the right word. They'll have a directory of lawyers in your state, and it'll usually be broken down by labor type. So you can look and try to find a labor lawyer. Depending on your issue, you may want a lawyer that specializes in a specific niche, like workers' compensation, right? So if you got hurt on the job, you don't want just a normal lawyer, you want a workers' comp lawyer. And it's important when we're looking at these lists and looking at lawyers to remember that there are two sides to labor law that people can focus on. There's the worker side, and then there's capital side. So you want to make sure that you're contacting lawyers and law firms that operate on the worker side of things, right? You don't want to, if you're just looking through, labor law, don't just call the number. Go look at their website. It should become pretty clear, pretty fast, that which side they're leaning, right? When you look at their website, it should be pretty obvious. Are they working for the companies, or are they working for the workers? And just make sure you're talking to a worker side. Labor, like I said earlier too, labor attorneys are often willing to do free consultations and work on contingency, where they are paid a percentage of if the case is successful. Nathaniel Gregory says, how many court systems are there that ignore or go for the business, and how do we deal with that? The bigger problem is that most people never report, right? It is a major problem that we consider labor law violations to be civil and not criminal. Like I said earlier, you steal you steal $100 from the cash register, you're going to jail, but your boss can steal $1,000 in your wages and they're not. That's a problem, right? And that's a foundational structure to our, a foundational problem to our in our labor laws. Going to court is always a risk, right? You can have a judge that doesn't like you. You could have an unfriendly jury. A lot of the times, these kind of things are settled, though. They don't actually get to the court case. They get settled out of court, and everyone goes home. But the reality is, when it comes to court cases, the problem is more that we have bad laws and less that judges aren't following them, right? If you have a cut and clear case that you are discriminated against, it's really hard for a judge to actually say, no, I'm not going to follow the law in this case. And if they do, you have the appeals process where you'll go up to other judges, right? And so to actually, go through the whole process all the way to the state Supreme Court or the federal Supreme Court and have it work out that, you need a dozen judges to then fight with you about it. Good night, buddy. I'll be done in a minute. Sorry, toddler bedtime. So you'd have to have a dozen judges all go against the law, and that's really not that common. What is way more common is that our laws are terrible, right? Like I said earlier, it is perfectly legal for your employer to foster a toxic workplace. That's not what we mean when we say hostile work environment. Hostile work environment only applies to the protected classes. So, I am not someone who puts a whole lot of faith in the judicial system and our court systems, but the idea that the big barrier, in terms of Nathaniel's question, is more: do you have the resources and the energy to keep fighting? When you get that one bad court at the bottom level of the justice system, do you have the money to appeal? Do you have the time to appeal? Do you have the willpower to appeal and work your way through? And that those are class issues by and large, right? And so that the ways in which our court system is part of the problem are generally systemic issues like class and just the fact that we, from the beginning, right, look past the flowery words in our founding documents, and what we will find is a government that was made by and for oligarchs to serve capital, right? So from the very, very beginning of our society, of American government and society, it's been pro-business all the way. When we talk about the flip that happened after the Civil War, that flip was mostly about which party was going to be more pro-business, and we see it today, right? The Republicans and Democrats fight over who's better for business. Our entire government is oriented around business. So the problem is more structural with our terrible laws and classist, systems than it is, having a judge that's just not going to follow the law. A judge that's not going to follow the law tends to lose their job, or be overturned more often than not. So to close up, right, I've covered a whole bunch. Like I said, this slideshow will be in the YouTube comments later tonight. It'll be the slideshow, and a bunch of links will be on the podcast post in a couple of days. It'll all be on our website at greensocialist.net. So you can look at these links in a little more detail. But here's a beginning list of resources. I actually plan to continue expanding it. But this is, based off what we've talked about today. This is an initial list. The National Labor Relations Board, the Department of Labor, both have really, really great websites that not only help you as a worker if you feel like you've been wronged, but provide resources on organizing and things like that. The NLRB has whole toolkits on how to organize your workplace, how to run social media for your union, like how to do this, that, and the other, how to negotiate a contract. Like the Department of Labor has similar, resources that can really help you advocate for yourself. Specifically calling out the wage and hour division of the Department of Labor, right? Because if we go back and we look at that slide about wage theft, right? At $23.2 billion per year, that minimum wage violations, which is a lot of what wage and hour deals with. But wage theft, like we said, it's $50 billion a year. So the Department of Labor's wage and hour division is who dives into that. So there's their link. Family medical leave is another really important thing for people to know, and they've got benefits and toolkits on that. OSHA, the Occupational Health and Safety and Health Administration, has again great resources. Same for the EEOC, the Equal Employment Opportunity Commission, and then a couple of resources that come out of the Department of Labor. The Worker Organizing Resource and Knowledge Center, workcenter.gov, is like a one-stop shop for resources and tools and help with defending your labor rights. And then worker.gov is another one that's kind of a catch-all for worker rights resources, right? So those are places you can, when you go to the NLRB, like NLRB.gov or DOL.gov or any of the other government websites, there's a lot of stuff, right? Like I said, the Department of Labor has a few dozen agencies under it, so that there's just a lot. You can get buried in it, you can get overwhelmed. Worker.gov and workcenter.gov are a whole lot more user friendly, a whole lot more tailored towards the actual workers and what they need, providing the resources that they need. And then again, we've got the IRS independent contractor determination, where if you're classified as an independent contractor, getting screwed on your taxes, not getting benefits, but your employer is setting your schedule and telling you what work to do on a day-to-day basis, and providing all of your equipment, then you can go fill this out and get an actual determination from the IRS that says no. This person is actually an employee. They need to be paid and treated as such. And so that's another resource. So with that, like I said, this Workers' Rights 101 is part of our monthly 101 series. It's every month on the fourth Tuesday of the month at 8 p.m. Eastern. It's organized by the Green Socialist Organizing Project, which was founded out of the 2020 Green presidential campaign. We mainly focus on political education, party building, helping electoral campaigns, and then issues campaigns. So if you want to get involved in our work, if you want to help us in our education working group, we would love it. The more people we have, the more content we can put out like this. We've got a great team that's been doing great work for the last few years, but you can go to greensocialist.net and sign up. And with that, I'm a little bit over the hour goal, but thank you for joining us, everybody. Like I said, my name is Chris Blankenhorn. I'm one of the organizers with the Green Socialist Organizing Project's Education Working Group. You can learn more about these 101 series of workshops that we've been doing for the last 2 years at greensocialist.net/101s. There we've got past videos, past audio podcast versions of every workshop, and the slideshows are linked. Like I said, through the end of the year, we're going to go back to our good old standard from 2022. In October, we're going to do Green Party 101. In November, we're going to do Eco-Socialism 101. And in December, we're going to do Organizing 101. One of the things that we're going to do while we're, that's kind of a break for us because we've already got those presentations, put together, and it's just about polishing. So one of our goals for the next 3 months while we're doing those is to take workshops like this, Workers' Rights 101, get the slideshow together and cleaned up, get notes together, and be able to present green locals with workshops in a box where you can, download the slideshow that you saw today. You can download notes. You can get a whole bunch of, links, resource links to your own research, and then you can go out into your community. And you can do a workshop on Workers' Rights 101 like we did tonight. You can do one on ranked choice voting like we've done previously. You can do one on decentralization. You can do one on the importance of independent politics. So that's something we're going to be working on going out through the end of the year and into next year, is taking a lot of these workshops that we've done and trying to make them turnkey. So that the Greens in their local communities can use them, can adapt them however they need, and can put them to use in organizing in their community. So thank you again very much, everybody. Have a good night. This episode will be out on most major podcast platforms Thursday morning, and you can go to greensocialist.net to learn more about us and to get involved. Have a good night, and thank you for joining.